I'm Michael Kirby, and I'm speaking to you across our continental country in a most unusual year. We have suffered together, and we have struggled together as a nation and as a world and as a species with the challenge of COVID 19. But hopefully, we're going to move out of that into the broad pastures that lie ahead. And I am here to help launch the Curtin Law Alumni communication for the new alumni of Curtin Law School. I pay my respects to the Indigenous people of Australia who are found in all parts of our great country. And I remind all of us, myself included, of the injustices that have been suffered by the first people of Australia, and partly as a consequence of the law. It is the duty of us, the lawyers, to make sure that these wrongs are corrected. I also pay respects to the Dean of Law, Robert Cunningham, who is taking part in this launch, and to the President, Tiffany Jiang, and to Kai Yuen Yo, who is the Vice President, and to the representatives of the legal firms and of the tax firms and accounting firms who will be present on this happy occasion of the launch of Curtin Law Alumni's occasion for 2021. Um, my end of my course in law happened an awful long time ago. It was in 1961, and it is therefore 60 years ago that I was in the same position as the alumni today, looking into the future, peering to try to ascertain what the law and life were going to bring to me and to my cohort of graduates at the University of Sydney Law School, which was then the only law school in New South Wales. We had had a pretty good uh, grounding in the law. We had a whole long list of compulsory subjects, very little selection, very little optionals in those days. We basically had to learn them all, from constitutional law to lunacy. It was all there, and when we were sent forth, we had been well prepared. We studied legal history so that we understood the way that particular aspects of the law fitted into the long history of English speaking people from whom our law derived. But in those days, the final court of Australia was the Privy Council, and the law books on the shelves were not, as I have, the law books of the High Court of Australia and of the courts of the states and the federal courts, but they were the law books of England because, by reason of the fact that the appeals went to London, we had to be pretty up to date and familiar with the thinking of the English law lords and the judges and barristers of England. But our tradition was a tradition which was one of honesty and integrity. And we learned tax law and company law, that was compulsory too. Uh, and we learned about the discipline that was required in the legal profession for us to perform our duties as lawyers, of the courtesies that were required in dealing with one another and with our clients. Never forget that for you, a law case is simply another day with stress and pressure and requiring your skills and capacity as a lawyer. But for the client, a case is generally completely unique, and they will always remember the experience, and they will always remember you for the way in which you upheld their rights and presented their cases if their cases came to court. So never forget that you are always on show and that you are always being judged, and that is a feature both for the judiciary and also for the practicing legal profession. I suppose the biggest change that has happened in the 60 years since I was in your position is the change of technology, the change that started with the photocopying machine and the dictation device and has moved rapidly through so many technological changes, many of them most beneficial, such as the access to the law that is provided by Ostly, which is such a different world from the world of the paper uh, reports and the difficulty of getting up to date statutes. Now, with the click of a mouse, you can be getting the most up to date law in Australia, in India, or in other countries of the world. This is the world of the internet that we have to learn to live in. But there were some features of the time when I was in your shoes that were very different from the times today. For example, we did not begin a conference with paying respect to the indigenous people. We didn't respect the indigenous people. They were denied their land rights, and it is a notable feature of Australia's parliamentary democracies, which go back to colonial times in the middle of the 19th century, that we never corrected those wrongs to the indigenous people by the parliamentary process. The democratic legislature did not fix up the refusal to recognize the native title of Indigenous people. In the end, that had to be accomplished by a decision of the High Court in Mabo against Queensland, and the later decision in the Wick case and in a number of cases from Western Australia, Ward against Western Australia, on which I sat, and which dealt with the post Mabo world. It is important for us to remember that human rights are a critical feature of a just legal system. And it is not true to say that Parliament always fixes things up in Australia. It did not fix up the injustice done to the Indigenous people by refusing to acknowledge their land rights. As well as that, women were greatly disadvantaged in the days that I was at law school. First of all, the class of about 100 law students included only 6 women. One of them was Bronwyn Bishop, at that time Bronwyn Setright. Another was a wonderful uh, uh, lawyer and subsequently the first woman judge in New South Wales, my late friend and colleague, Justice Matthews. Jane Matthews was a wonderful judge, and she was sitting there with me in a class of 100 boys and 6 women at the Sydney Law School back in 1961. The injustices to women in the law were very rarely mentioned. And I never raised my hand to ask, please, sir, why does a woman take her domicile from her husband in a divorce case? Why does the husband not take his domicile that founds the jurisdiction in divorce law from the wife, who has generally the responsibility in those days for the children. Uh, we did not respect people of different races. Back in those days, we had the White Australia policy, and the White Australia policy was inherited from colonial times and was strongly supported by all of the political parties and by the people of Australia in those days. It wasn't until the late 1960s and thereafter that the discrimination against people of different races began to fade away and new laws were enacted. And yet, when I was at law school, I never asked a question why we had the White Australia policy. This was just something that we had to accept, and we did accept. That was the way of those times. Likewise, with gays, this was something that I noticed very clearly in my law school when my first year subject of criminal law was taught. It included the section dealing with so called unnatural crimes, the laws that targeted LGBTIQ people. And I knew that those laws were targeting me. But never did I raise my hand and ask, why are these laws in place? Why have they not been swept aside with the knowledge that science has already brought? It was just something that had to be accepted and in silence by those who were affected and their families. And I think that is the main lesson I want to leave with you about the duty of alumni and of lawyers. We have a very special and unusual occupation. It is unusual because we are concerned with a branch of government, the legal and judicial branch of government that brings law and justice to all of the people of our country. And I would enjoin all of you to be more questioning about the law and more questioning about the injustices in the law and never to accept the injustices that burden our fellow citizens. Injustices against women survive into this time, and they survive in the legal profession and in the governance of our country. And we, the lawyers, have to lead the way from discrimination and injustice against all people, against Aboriginals, against people of different race and colour, against LGBTIQ people, against people with disabilities, against women and girls, and against all those who suffer injustice and discrimination in our discipline of the law. The law has been too patriarchal, and it is the duty of you, as the lawyers of the future, to lead the law out of such discrimination and into the principle of equal justice under law for all. This is not just something that we carve on our courthouses. It is something that must be written in our hearts, and it is something which we must learn at our law schools, and we must learn to be questioning, and we must learn to search for justice. So I send best wishes across Australia to the alumni of Curtin Law School. I'm looking forward, I hope later in 2021, to coming back to Perth and to making a visit to the famous Curtin Law School. And I hope when I do so, I will meet some of you in person and that we will put COVID 19 behind us and we will advance the cause of equal justice under law, because that is the great privilege of being a lawyer.